Are you an established small business owner or aspiring entrepreneur? Would you like professional advice to help your business grow and succeed? Well, look no further. The Virgin Islands Small Business Development Center is the territory's #1 resource to move your business forward. Enjoy no-cost advising, low-cost training, and technical assistance from experts in both the public and private sectors. The VISBDC is nationally accredited and sustained by the University of the Virgin Islands and the U.S. Small Business Administration. Visit us at our locations on St. Thomas, St. John, or St. Croix, and follow us on social media at VISBDC. For easy access to all our training and networking events, be sure to join our newsletter and download the VISBDC app. The Virgin Islands Small Business Development Center, here to help your business start, grow, and succeed.
Hi, good afternoon, everyone, and welcome to the VISBDC's hosting of the Patent and Trademark series. Today's session is entitled, Learn About U.S. Design Patents. Allow me to introduce today's lead presenter, Mr. Garth Rademaker. Mr. Garth Rademaker began working at the USPTO office in 2005, examining applications claiming designs for a wide variety of articles, including photocopiers, bottle openers, tires, and flower pots. In 2013, he became a Supervisory Patent Examiner working in Art Unit 2911. He also began working with the Patent Training Academy, and for nearly 10 years had a significant role in the training of all new design examiners. In 2017, Garth moved to Denver and also became part of the Rocky Mountain Regional Office Management Team, where he began participating in outreach events. While he no longer works at the regional office, Garth currently heads Art Unit 2922, as well as continuing to play a large role in design-related outreach events and training new design examiners. Here's a friendly reminder to put your questions in the chat, and they will be addressed by the presenting team either directly in the chat or later during the question and answer segment. A copy of this presentation will be attached to the post-survey email. We encourage you to take a few minutes after the training to fill out the survey that lets us know how we're doing. So without further ado, presenter Rademaker, the floor is yours.
Hi, everybody. Thank you for that introduction. Welcome, everyone. My name's Garth. I love design patents. I'm here to tell you all about them. I don't like usually starting off with an apology, but I will tell you I've given this presentation, I don't know, 50 times, 60 times. But this is the first time I've done it with these slides. So there may be a couple bumps. That's okay. I promise no matter what we're going to talk about, no matter what questions you have, they will all get answered. We're going to have some fun. So let's start talking about how important design patents can be for small and medium-sized businesses. When we talk about designs, what we're talking about is industrial designs, a design applied to an article. This is sort of independent from art. Design patents occupy a sort of strange space between copyright, which is for works of art or literature, and utility, which is like how something functions, the way it's made. Design is focused solely on the way an article of manufacture, a saleable good, looks. And in the US, this is protected with design patents. That protection is limited to the United States. You can have all the patents you want in the US, and if something is happening in Germany or Japan, it's only helpful here. And also an important point to note, because some people get mixed up about this, design patent rights are enforced by the court system here. And that doesn't mean that the courts go after people for you. It means that basically if there is an issue where you have a design patent and you believe someone's infringing on it, you would handle that through the court system by suing them or dealing with an attorney. Other countries do do design patents and register designs. Most other countries register designs, which is a bit of a different system. In the US, when you apply for a design patent, that application is put into a queue and eventually it's examined. And one of us makes sure that what you're doing is novel, it can be understood. And then if so, then that patent issues and grants you those rights. In other countries, they'll register the design, which is more of a, almost more of an immediate thing. Usually those patent rights registration rights are conferred that day or the next. The difference being you have that registration, but you don't know how strong or valid it is until you go to enforce it later on. So there's a bit of a push and a pull there. There's this other thing called unregistered designs, which I will admit I'm not very familiar with. Some countries offer these rights where basically, as long as you can prove that you've been selling this design for a certain amount of time, you can prove that it's yours, then that does confer some form of protection. Again, I don't know much about it. It seems like the kind of thing, when I've read cases about this, I always tend to think it would be a lot easier if they just registered their design. But like with the US, any rights you get from a registered design or an unregistered design are specific to those countries where you obtain them. Not there's no such thing as a worldwide patent, as wonderful as that would be. And again, the design patent protects the way something looks. It does not protect what it's made from or how it's made. Honestly, it doesn't even need to work. And that's okay. As long as it is something that you can sell. We'll get some more into this terminology later, but the configuration or shape of an article, what it looks like, surface ornamentation applied to an article, which is like surface indicia as opposed to the underlying shape, or the combination where you've got something with indicia printed on it. And just some examples, an iMac, the VW Bug, My Little Pony, and the old Nintendo. These are all things that have received U.S. patent protection. We'll get into about terms in a little while, but this is the kind of stuff that we're talking about. Articles that are sold in stores. And again, this is to differentiate it from something like a painting or a sculpture, which is a single piece of art. The idea with designs is that the design makes the article more attractive to a purchaser. We buy things for all kinds of reasons. When you are going to buy a car, you might go buy a car and you're thinking very much about safety, you're thinking about fuel economy. One thing you're probably not maybe consciously thinking about as much, but you're definitely thinking about the way it looks. That car can be extremely fuel conscious. If you don't like how it looks, odds are you're not going to buy it. Now, that said, design protection is not about how good something looks. It's just about how it looks different from everything else that's out there. So we are not making judgments about if your design is prettier or better than someone else's design. We are just looking at, did someone else design this the same way already? Patent rights. So if you obtain a US patent, you get rights to be the sole seller of that design for 15 years. And if somebody else starts selling that same design, then you can go after them for infringement. And this is, and first of all, when you put the time and effort into designing something, it's nice to know that once you've done all that, the research and development and everything, that someone else can't see how well you're doing and say, oh, I'll make mine look exactly the same as that. And it does, like as I mentioned, it's only for 15 years, but I think a lot of companies will use that time to establish, basically establish that design, the whatever appearance it has, is associated with your company, and then they can seek trade dress after that or trademark rights. It always surprised me. This is one of these things I used to not know that trademarks could be for the appearance of physical articles. It's not just things like logos and slogans. But why does nobody make goldfish crackers except for Pepperidge Farm? They designed that. I'm not sure when that came out, but early 1900s, I guess, somewhere around there. But they have a trademark for that now. So their design protection, if they ever had it, has long since lapsed. But now they have a trade dress, and they can still be the sole people who make that product. When you get a design patent, or any patent for that matter, US patent, it gives you the rights not just to be the sole person to make and sell that, but also it gives you the right to license its appearance to someone else so that they can make it. You can sell those design rights to a different company. I know it's been a very long time, 7 or 8 years ago, I was giving a presentation to a different SBDC. And one of them, I had never thought about this, but one of them noted that even if your company does not do well in whatever regard you're trying to succeed in, having a patent is still it's property, and it's something that you can sell. It also gives your company a bit of a boost image-wise, because if you're a small company, then you perhaps are very unknown and you're going into larger meetings with people and they don't know who you are or what you do. It's a gamble. And when you can say, well, we have a patent for this, what you're saying is, we already have someone out there who says that this is a unique, novel approach to this. So it's not already being done. Okay, let's talk about the nitty-gritty of US design patents. As I said, they protect the ornamental appearance of an article manufacturer. They are examined substantively, which means that you will have an examiner who will look at that application. They will review all of your drawings. They will review everything you said in the application. They will go out and they will do a search of the prior art and see what else is out there. Did somebody already make this? And so when you do get that patent, it shows that there's a presumed strong likelihood that you are the first person to have designed this, and those rights are very difficult to undermine. Again, it's the protection from those rights is for 15 years. I will note that term back in 2015 with the America Invents Act, we went from a 14-year term to a 15-year term to be more in line with international standards. And so if you ever hear that a design patent is only valid for 14 years, that used to be the case, but no longer is so. And again, if you find someone who you think is infringing on your patent, then it is your obligation to go out and you can contact them. Many of these things are solved with a cease and desist letter, and then from there you can do whatever you sometimes what you want is you want the person to stop. Sometimes you say, well, you can keep making it, but you need to license this design from us and obtain that, protect your rights that way. So, design patent rights require 4 things: patentable subject matter, as we mentioned, it's a design for an article of manufacture, as opposed to being the article itself, as opposed to being a concept. If you design, let's say you design a bottle opener that looks like a fish. First of all, if it looks just like a literal fish exactly, that's not something that you designed. That's nature, so that would not be patentable subject matter. But if it does have a different appearance, something cartoonish perhaps, you're getting a patent for that specific appearance, not the concept of a fish-shaped bottle opener where any fish would be infringing on it. It needs to be novel, which means that no one has done it yet. As I mentioned, examiners will go out and search for what art existed at the time to see if you were the first. It also must be non-obvious, and that's a little bit more tricky. But what that means is, if I find one piece of prior art that looks very similar, but there are some differences, are there other references that teach modifying that design to look like whatever design you've applied for? There's a lot of nuance that goes into that, but the idea is that if it's an obvious modification over something that already existed, then that's not going to be considered patentable. And the main thing for design patents, it probably depends upon what kind of articles you're talking about, but the main thing I think for design patents is sufficiency and clarity of the disclosure. We need to know exactly what this design looks like in one specific way. Again, you're getting rights for the specific visual appearance of something, not a general idea of, oh, it's a calculator, it's got some buttons. Okay, well, I already covered that, didn't I? So here's an example. Sometimes we do see applications for disembodied designs. It's a picture of something and says, well, we want to apply it to all kinds of stuff. An embodied design, you can still get protection for just that surface indicia or whatever it is, but you need to show it applied to an article. Something about design patents, you don't need to protect or claim everything that you are showing us. So most of the time when applicants are showing us something that's not part of their claim, they put it in dashed line or broken line. So in this case on the right, the protection would be for this spider web indicia, but the underlying mug does not form a part of the claim. And that can come in very handy because, for example, you'll notice the handle does not have the indicia on it. It's not part of that claim. And if somebody were to make, for example, a goblet wine glass that had this spiderweb print on it, the design rights from this probably would still apply very closely, because as long as it still has that general shape, the underlying article was not part of that claim. So it's a much broader form of protection. To get back to the slide, I suppose, the actual disembodied design, though, to apply to anything, that's not proper for a design patent. Here are 3 examples of what is proper. The middle one is probably the most common. They say the configuration embodied in an article. It's the shape and appearance of that design. Also very common, we do see, like in that last example, sort of the surface indicia applied to an article, but not claiming the underlying article. And then, of course, on the right, there's both. That's claiming the appearance of that tumbler as well as the indicia applied to it. As I mentioned, you don't need to protect the entire design. In this case, they're just protecting the side panel of a car. One thing that when people call me and say, they want information about how to best to protect whatever design they have, I often suggest to them, I can't tell them what to claim or how, but I suggest to them it would be very important to think about, don't just think about what you've designed, think about if you release your design and it starts selling like really well, and the infringers will come out of the woodwork. And very often they won't make the exact same thing. They'll try and make something that looks similar, but is different. And if that was the case, how would they approach that? What features are the most important that they would include? And then what are ones that are less important that they might change? And then make sure you focus your protection on those parts that are most important to your design. Okay, so as I mentioned about this, merely copying a well-known article, something from Nature, that is not considered patentable subject matter. So, for example, these middle one is these are plastic fruits, like you might put in a bowl that they don't decay, so it's a centerpiece. That would not be proper subject matter for a design patent, because whoever designed this did not invent the appearance of a pear or an apple. The one on the right is interesting, a bust. There's some design stuff that goes into that. Someone decided where to cut the bust off, how does the podium element look. But for example, if you applied for this design and the examiner found a similar podium with a bust on it, they would not need to find that exact person as the bust, just the human form in general, because the human form is not considered patentable subject matter. So when you protect this, you're protecting the ornamental design. You're not protecting its function. It also must not be primarily functional. We often will describe that as having the form as dictated by its function. And the appearance must be a matter of concern. When we talk about the appearance being a matter of concern, what we usually talk about is the lifespan of the design. And that lifespan is considered to be from when it leaves a factory floor to when it ultimately meets its disposal, it's thrown in the garbage or whatever else. If the appearance of this, whatever you're trying to protect, is never a concern during that lifespan, then it cannot be considered ornamental. So for example, if we're talking about a hinge inside of a hard drive that you cannot see unless you break the hard drive, that would not be considered to have an ornamental, the ornamental appearance of it would not be considered to have any concern to the public, because you'd have to destroy the article to ever see it in the first place. In terms of functionality, this is a very famous design patent case. This is the design for the business end of a key blank. And that was designed to fit into a lock, not to have its own ornamental appearance. The designer of this key did not come up with this on their own. They designed it to fit into an existing lock. And so that was, at the time, that was accorded a design patent, but that ended up being invalidated because of its functionality. The functionality was the primary concern when that was designed. I do want to say, I mean, pretty much everything has a function, right? My shirt has a function. It's not to say that these things can't have a function. In fact, if they didn't have a function, now we are talking about art, which is not proper either. The design just can't be, the article, rather, the design cannot be primarily functional. So if it's 51% dictated by function, then that would not be proper subject matter for a design patent. As I mentioned, it must be novel, and the standard for novelty is actually very interesting. It's a lot of people talk about it as if the design is identical to something else, and it's a more fuzzy standard than that. What we talk about is usually the ordinary observer, giving the attention that an ordinary purchaser might give something. So what does that mean? I work with many of the people I work with, not many, but several of them are sneakerheads. They collect high-end sneakers. They're the kind of person who will get up at 4 a.m. and stand in line to get the new Air Jordans or whatever. That person is not the ordinary observer. That person is an expert. They could look at my shoes right now and tell me exactly what kind of sneakers they are and when they came out. That's an expert. My mother is on the other end. I would send her to go buy me some shoes, and I'd say, I want to get these low tops, and she'd come back with high tops and wonder why I was annoyed about that. And she's not the ordinary observer either. She's a dope. But the ordinary observer is most of us, right? I see some shoes on a friend and say, wow, those are really cool. And don't ask about them specifically so I can go in and ask for the name. But I say, oh, wow, those are really cool. And then the next day I go to a shoe store and I see a pair of shoes and I say, this is them. If that's not them, then that design is not novel. It was one of them anticipated the other. So there's a bit of a fuzzy standard there. We already delved a little bit into the non-obvious thing. I won't get too much further into that because it is a bit more tricky. But it's things like, for example, let's say you designed a Tupperware bin, and it's designed to hold food, and it's got this tall rectangular shape. And the examiner finds a very, very similar bin, but it's half the size, it's half the height. The idea of changing the proportions of a food storage bin to accommodate more food or a different kind of food is that's not a new thing. It would be obvious to modify that one design to have a somewhat different shape. So that's the best example of that I can come up with. Okay, so when you apply, you're going to give us drawings, which are the most important part of your application. This is where you show us exactly what your design looks like. You're also allowed to provide description. And usually with design applications, that description is very brief. We require you to have a specification that says, for example, figure 1 is a perspective view of my design for a toaster. Figure 2 is a front elevation view thereof. And then it just goes down the line describing every view. Most applications, it's across there's a lot of variety, but generally speaking, we see 7 views: front, back, top, bottom, left, right, and a perspective view. If your design is more complicated, you can include multiple perspective views. We will need to understand the appearance, the exact shape. For example, if you had the bottom of it had the very complicated punt with some contouring in there that could not be seen from the sides, a bottom plan view would just show us these contours, and they would not be understandable because I can't tell the depth from a plan view, but a bottom perspective view might help me understand that. So that's fine to include additional views. You can also show the design in multiple states of use. For example, you have a laptop that's shown both open and closed. If something's not shown, if you never show the laptop open, that's fine. We just understand that whatever's happening inside there is not part of your claim. There are some instances where you can describe the design. It's very tricky because I could go into very high detail describing a design, and you probably all would have different images in your head. But to say, for example, here's a left side view, the right side view is a mirror image of that. That's fine to do. We very often will have designs for things that come in pairs, like shoes or gloves, where the applicant might say that the left glove is a mirror image of the right glove, which is fine. That can be understood with the aid of the drawings. So there are kinds of description you can put in there. And in fact, the claim, I'm not sure how familiar any of you are with utility patents. The claims can be quite complicated, and pages of different claims. For designs, we only have one claim. You can only claim the design for you only claim one design, and this claim language is actually statutory. It must look like this. Is a little bit of tweaking that can happen, but I claim the ornamental design for whatever the article is as shown and described. If there's no description, you can leave off the and described. But basically it's saying, if you want to know what I'm claiming, don't look here, go look at the drawings. They are their own best description. Now, you can include multiple designs in an application. They just must be patentably indistinct, right? So in these examples, a hanger, having the crossbar at the bottom of the hanger, I'm sure is something that's well known in the arts to have or not have that crossbar. These boxes, again, these are boxes that are different shapes to hold different things. Changing the proportions like that would not be considered a novel thing to do. In the event that you do file an application that does have different designs, let's say you filed this application and it had all 5 of these designs in it, the examiner would figure out which ones could stay together, and they'd say, well, these 3 boxes, they can be in one group, and these 2 hangers are different, they'll be in a separate group. And then they would send you a correspondence where you would have to choose which one you want to proceed with. And you could file the second set of designs as we call it a divisional application. Provided you file that within the pendency of that application, you retain the filing date and you can still proceed with that. So sometimes I'm asked about, is it better to take all my designs and stick them in one application? Or is it better to file multiple applications where if they're too similar, the examiner is going to give you a different kind of rejection for that. You can still obtain the rights to these. It's just a little more complicated. And I think the answer for that, and let me emphasize, I've never been on the applicant side of this equation, so I don't know. But it appears to me that if you file everything at once, the examiner may send you an action saying choose, and then you have to file additional applications. It may be fewer applications than you would have thought, so you may save some money with that, but it's going to take you longer because you have to go through that process. Whereas if you filed them all at once, you would get your patents substantially all at once. So it might cost more for additional applications, but you would get those rights faster. So it depends which one is more important, time or money. Okay. To file with us, the best way to file is electronically. You can go to our website, uspto.gov, create an account, and you can file this application electronically. There is something which I haven't mentioned yet called a Hague application. As I mentioned, there's no such thing as a worldwide global patent, but you can file with the Hague, and that basically they will take your application and forward it to multiple multiple countries that participate under this Hague agreement. It's been a long time since I've checked. I want to say there's over 100 countries that participate in it. And they will take care of some of the formalities, forward the application to all the participating parties, and then you would prosecute those applications with each of them individually. Most Hague applications, I believe most Hague applications are filed directly with the Hague. You can file that application through us. So it would not be a domestic application. It would be a Hague application, which we would forward on for you, and then presumably they would forward it back to us, provided you designated us as a country. When you get an action from the examiner, we strive very hard for clarity in prosecution. We want you to know what's happening. If the examiner looks at your application and says, there's something wrong here, I can't allow this yet, they need to be clear in their written action to you about everything that is wrong with it. And I mean, even if it's allowable, they still may put some stuff on the record to make things clear. But the burden is on them to show. For example, if they say, well, I found this piece of prior art, it looks substantially similar to the claimed design, and they give you a rejection, they're required to show you that art to provide the rationale for why they think it's substantially similar. If they say, for example, there are some parts of this that we don't understand, the burden is on them to tell you what we cannot understand. I like to say, nobody knowingly files an application that they know is flawed. So we need to tell you what those problems are, so that hopefully you can correct them and get the application allowed. This mentions these statutes. It's not important to remember these. 102 is the statute that covers novelty. 103 is the statute that covers obviousness. And 112 is the statute that covers whether or not we can understand your claim. So, so let's say you receive a rejection. What do you do next? First of all, you're allowed to simply abandon your application. That does happen. As I mentioned, that when you file an application, it kind of goes into a queue, and we begin prosecuting it when it comes up. There's a bit of an intervening timeline there, and it may be that in that intervening, whatever time it is, 6 months, a year, you've started to sell your product and realize that you want to change its appearance, and you're no longer making that old design, or you realize that nobody wants this design, I'm going to stop pursuing this. There's no need to continue putting good money after bad. You can abandon the application. You can also argue with us and say, the examiner misunderstood something, and here's where they're wrong. You can amend the application to fix any inconsistencies, to help us better understand your design. And very often, no matter which one of these things you want to do, it can be very helpful to you can call the examiner and have a telephone interview with them, or a video interview where you can see one another face to face. And that can be very helpful. I will tell you, especially when I am dealing with applicants who are not attorneys. Most applicants have attorneys, but if you are not an attorney and you're filing on your own, that is perfectly fine to do. It is a legal thing. It's a lot of nuance to it. It can be very helpful for those applicants to call the examiner and discuss this, because the examiner can often put everything in terms that are more relatable to the general public, as opposed to reading our manual of practice and procedure and thinking, I have no idea what any of this stuff means. Right, so let's say you got a rejection and you had an interview with the examiner and they helped you figure out how to amend your drawings. You can file that response, and then it might be a notice of allowance after that because you fixed it. Or it might be a final rejection where you didn't quite fix everything, and there's the rejection has to be maintained. You're also not allowed to introduce new matter. I mentioned before about if you show us the bottom of something and there's all these different contours that can't be understood, once you file that by itself and there's no bottom perspective, it's often impossible to show us that bottom perspective view without introducing new matter, which would land you in a rejection. So very often what happens in those cases is the applicant amends the lines and makes the broken line, removes that portion that couldn't be understood from the claim. If there are still additional formal matters that have not been addressed, you might receive this other action called a quail action. It's not a rejection, but it's not quite an allowance. It's just saying there's a couple things we need to tidy up before it can be allowed. And finally, if the examiner sends out a rejection and you overcome it, it may be that in that intervening time period, several months, they found additional prior art that predates your claim, and they may send you a new non-final rejection. So, as you can see, it's all very simple. I'm not in love with this flowchart. The section on the left in green that kind of deals with office formalities that are dealt with when you file, usually between when you file and when that application is put on an examiner's docket. And the part in the yellow on the right deals with post-allowance, publication, getting the information so we can actually put your patent together and make it look really good. And the middle part is this complicated chain of events that could potentially be the order of your prosecution. It's tempting to think, oh, well, it's okay if I file and I get an allowance. If I don't get an allowance, then I get a rejection, and then I overcome the rejection and I get an allowance. These applications, they go in all kinds of different order. It can be rejected and then given an allowance, and then the allowance withdrawn and then given a new rejection. If that's very rare, but it can happen. It can be given a final rejection and then back to a non-final rejection. There's no linear way to think about it. But the idea with all this is the examiner is doing their best to make sure that whatever happens with this is legally appropriate. And so that's why it can be complicated. If the examiner finds new prior art down the road, they can't just say, oh, well, I missed that. Let's grant them the patent anyway, because I already said it was allowed. We would have to withdraw it from issue. And I also want to emphasize, I hear a lot that examiners are just thirsty to reject every application that comes across their docket, and nothing could be further from the truth. Examiners are actually incentivized to allow applications. It's much easier for them and less work. So if they're giving you rejection, I mean, what they want to do is they want to ideally help you understand how to fix your application so that it can be allowed. Or sometimes we look at something and we go, I just don't see a way. And we always have an open mind, but at least to try to communicate the severity of what's going on to you so that you know best how to proceed. Again, if we look at the design and we say, there's literally no way I can understand this. I see no way to amend this. Something happened, the drawings came through and they're just garbled black shadow shapes. There's nothing to be done here. We want to let you know that as soon as possible so that you don't spend a bunch of money amending to nowhere and wasting it, so that you can do something to try and salvage something with a new application or to do whatever you think is best next. These numbers are a little bit older, so back in about 6 months ago in March. But our office first action pendency was 17.2 months. I believe that actually came down to about 16.8, 16.9 now. We're trying very hard to reduce that to below 12 months. We'd love to get you all first actions in the first year after you file. But these are averages. If you filed today, on average, you would receive a first action from us, a first substantive action, in 17.2 months. I know it's a very long time. But the total pendency for most applications, the average pendency, is 23 months. So once that ball gets rolling, it tends to go very quickly. There is something you can do called a rocket docket. That's an informal term, but there's a way to file for an expedited examination, and there are some fees associated with that. But when you file for one of these, there's some things you have to pay some fees. You have to have done a prior art search on your own and let us know what you found. There are a couple other little hoops to jump through. But if that does get, it's a petition, and if it does get granted, then the average time for that application to be examined following that grant of that petition is only 1.3 months. So that is a way to get your application bumped to the top of the pile, so to speak. Finally, as I mentioned, we want to allow your design patent application. We truly do. If we're rejecting the applications because we feel it's necessary, and the rate for allowance in designs is significantly higher than in utility. It's 83%. That's pretty good. So if you do file with us, the odds are definitely going to be in your favor. And the recommendations, right? I very often get the question of, like, what do I do to help this design get allowed more quickly? And as I mentioned before, the drawings are the most important part of this application. I strongly recommend hire a draftsperson to prepare good quality drawings, especially one that has experience, not just drafting for patents, but for design patents. There is a big difference in utility. They don't, depending what the claims are, they don't tend to care how it looks, or if they can understand the appearance of this thing in the drawings. And I'll also say okay, so you're saying, well, I want to file this thing, but I want to make sure that I want to disclose it in one single way so you understand it. I want to disclose all of it. You can't introduce anything new after you filed. A really great thing to do that's very simple is you can just, if you have the physical article, you've already designed it, take a bunch of pictures of it and file it as an appendix. As long as you file that appendix on the filing date, you can rely on that disclosure for any amendments you have to make later. It's a great way to get out of problems where, for example, you didn't show the back sufficiently and now you want to show it from a different view. So that would be my closing bit of advice. Thank you all, and I hope there are some good questions because we got a whole 20 minutes for them.
Sad news, I don't see any questions.
No questions. Well, I can just yammer on about a whole bunch of stuff if you like. Okay. So this is something that this is not about design patents, and this is nothing that you'll probably ever encounter if you're trying to file for a design patent. But it is something, when I read this, I understood the complexity and how interesting design patent protection can be. Let me tell you all about a case called, what is it? In the application of Charles P. Sterling. Charles P. Sterling, this is back in the 1930s. He was a designer of stationery, and he developed this method where he took a piece of paper, like high-end paper, and he crumpled it up, and he flattened it back out, and he put ink on top, and then he scraped all the ink off, and the ink stuck in all the cracks and made this fractured spiderweb type design. And then he put a piece of glass on top of that and photographed it, and that became his design for stationery. And what happened was, I don't know how this, I don't know how the examiner knew about this process, but they basically, the examiner rejected the application for not being designed by the designer. All the back and forth, the prosecution of that is lost in time, but the court, it resulted in a court case. You know, he tried to pursue these rights. They went to a judge to say, I should get these rights. And the courts decided, and their logic was really interesting here. They said he had designed a novel way of making stationery. This is a new approach. It was very novel. That's the how you make it part. That's a utility thing. The actual design of the paper, he had no actual control over it. So he could not have been said to have designed it. If he had done something like carefully pleated the paper and made these specific geometric shapes and done the same process, that would be different. He had control over the resulting design. But in this case, with this, he crumpled it up. He had, you know, he might have had, again, it's a concept. It's this idea of this crumpled look, but he had no control over that design. So he was said to have not, you know, I mean, as much as it is his design and he can make and sell it and all that, he could not have been said to have any control over that design. So I read that case and I thought that was just nuts. I think, you know, if nothing else, I hope that you leave here with an interest in intellectual property. I know, for example, I remember it was a long time ago now, but there was some nature photographer where a monkey took his camera and took his selfie, essentially, and he tried to get protection for that photo, and they were like, no, you can't get protection because you didn't take it. The monkey took it. This is intellectual property can be hilarious.
Wow. Thank you for sharing. We have one question that came into the chat. Can you explain the difference between utility and design again, please?
Yeah, absolutely. So utility patents, most of the office deals with utility patents. The designs is only about 2% of the office. But utility patents protect the way something is made or the way it functions, what it accomplishes. And I mean, that can be everything from, like, you know, how does an internal combustion engine do it, right? How does it turn gas into power? That's all about the way it functions. In some cases, it can be about the way something is made, the way, for example, noodles are extruded. Maybe you invented a better method for that. But it's about method and function, as opposed to design patents, which are solely about the way something looks. You know, you all probably have several different types of glasses in your cupboard at home. Wine glasses and water glasses and juice glasses and lowball glasses for cocktails. And every one of these things functions the exact same way. You pour liquid into it, and it contains that liquid, but they all have different appearances, right? And so that's what we're focused on. I mean, I don't know how many, but I know that, for example, we still issue design patents for teapots. The functionality of a teapot has not changed in centuries, probably tens of centuries, right? You put water in it, you boil it. It's just a vessel. But the appearance of teapots, people are designing those every day. Does that help?
I think it does.
Maybe.
Great. Yeah, that person says great. Thank you.
Sure.
Okay, so I guess you did a pretty good job explaining everything so thoroughly enough that no one has any more questions. So I guess we can go ahead and go on to the next slide and formally close out.
All right, fantastic. Thank you.
No problem. Okay, the VI SBDC has so much more in store for US VI small businesses. You can visit our website at www.visbdc.org. Download the VI SBDC app on your mobile device from the appropriate app store. Like and follow us on Facebook, Instagram, Twitter, Google Business, and subscribe to the VI SBDC YouTube channel for new uploads of our on-demand webinars. Here's a preview of our upcoming trainings. This Friday, we have the USPTO back again. That's going to be at 2 p.m. They're going to be presenting on patenting apps software, US patent practice. On Friday as well, 11 a.m., we have the VI Energy Office, and they're going to be presenting energy efficiency tips for US VI brick and mortar businesses. On October 4th, we have a presentation entitled Effective Business Communication in 2024. On October 11th, in person, we have a workshop. It's US VI Marketing, Learn How to Pitch Your Business. All righty, so I don't see any more questions at this time. So I want to give a friendly reminder to check your email. There's going to be a PDF version of this PowerPoint presentation, along with a post survey that lets us know how we're doing. And on behalf of the entire VI SBDC network, before I close out, we have one more question.
Okay.
Can I look up designs to see if they have been patented? And if so, how do I do it?
Absolutely. That's a great question. If you go to our website, uspto.gov, there is a patent searching tool available on our website. It's actually substantially the same thing that our design examiners use. And you can look for patents that way. We also do, examiners don't just look for patent documents. They also look for they look out in the world to see, does it exist? So we look at foreign patents as well, or registrations. But most of our searching now, to be honest, is done on the internet, just using Google and looking at Amazon. So I would encourage you, if you are designing something, doing a preliminary search to see, first of all, before you apply for a patent, to know that somebody else already designed this or has patent rights for this would be extremely good to know. It's a good thing to know up front. But you can also use that information to help you. So if you see, like, if you go online and you're like, oh, wow, someone's been selling this since 2015 and it looks very similar, it can inform what you do next, right? How do I want to tweak this so that I retain the design that I'm trying to do, but I want to make sure it's definitely differentiated from that other person's design.
Okay, thank you for that answer. And I guess that would be our last question. So on behalf of the entire VI SBDC network, we thank you. We thank the USPTO for collaborating with us on this series. And we want to thank everyone in the audience for their time.
Thanks for having me. It's been a lot of fun.
No problem. All righty. Until next time, thank you, everyone. Enjoy the rest of your day.